All right, you've convinced me, you've twisted my arm. We'll go look at Disney v. Midjourney and see how Cox might be shaping up that one too, see what might be going away in that one. Because if you remember, this is the one where they had all of those pictures of, look, minions, you can make minions with Midjourney, therefore, Of course, as I pointed out, absolutely no examples of that were copyright infringement because they were all made at the behest of Disney for the lawsuit. That doesn't count. You have to show actual infringement, but now since Cox, it's even harder than that. Because it's not enough to show that people were infringing, not enough to show that Midjourney knew about it, not even enough to show that Midjourney did nothing about it. Cox knocked all of that down, but this one's interesting because Disney was being a little tricky and sneaky in trying to take two different theories of copyright infringement and just clash them together when they didn't really go, instead of pleading them as two different counts, and that might be their undoing. Because as Midjourney points out in their motion for partial judgment, the focus of this motion is plaintiff's omnibus secondary copyright infringement claim. That claim is, in fact, two distinct claims, one for contributory infringement and the other for vicarious infringement. Plaintiffs have commingled them under one label, but they're independent doctrines with different elements. And following the Supreme Court's decision in Cox, which clarified the standard for contributory infringement, that claim fails as a matter of law. An online service provider cannot be held contributorily liable for copyright infringement merely because some users exploit its service for that purpose. So following Cox, Midjourney wrote to plaintiffs and explained why they have to drop their contributory infringement claim. In response, plaintiffs conceded, yeah, we can no longer pursue that, but refused to withdraw the entirety of the claim, insisting that their pleadings state a contributory infringement claim under an inducement theory. They do not. Neither complaint alleges the type of conduct required to plausibly state a claim for inducement, namely, affirmative encouragement of others to infringe. The complaints are notable for what they do not allege. They do not allege a single instance in which any of the plaintiffs' asserted works appeared by default in the gallery on the Explore page. Other than their characterization of the Explore page and search features as advertising, they also do not allege that Midjourney has ever promoted images that allegedly infringe plaintiffs' asserted works. And they do not allege that Midjourney has ever suggested search terms containing plaintiffs' character names to users. In other words, no inducement, no tailoring, no material contribution, none of the things that Cox requires. Midjourney asked plaintiffs to amend their pleadings or stipulate to dismissal of contributory infringement. Plaintiffs deemed it unnecessary to do so and doubled down on their non-material contribution theory based on so-called inducement. Prompted for the factual basis of the latter, plaintiffs pointed principally to the Explore page. Because what happened is, like, users make an image of Iron Man, someone else goes to the Explore page, types in Iron Man, searches for Iron Man, finds Iron Man, and then uses that prompt to mix up their own picture of Iron Man. And let's say that what those users doing is infringing. It's not necessarily, it could be fair use depending on what they're using it for. But let's say it's infringing. It's infringing by those users. It's not infringing by Midjourney. And that's the problem. Midjourney has to be actively involved in the process. And their whole claim seems to be that Midjourney made the Explore page, and the Explore page can do this thing. Therefore, Midjourney is actively participating and inducing. No, they just made a search engine of their own stuff. Midjourney again asked that plaintiffs drop their contributory infringement claim in its entirety. They met and conferred on June 3rd, during which plaintiffs still refused to voluntarily amend or stipulate to dismissal of the contributory claim, despite having conceded that at least the material contribution theory was untenable. During the call, listen to this, plaintiffs also characterized their contributory infringement claim as a catch-all or backup to their primary claim of direct infringement. Exactly what you're not supposed to do. And judges don't like it when you do that. A separate claim is a separate claim. It's not like, oh, we'll make all these allegations, and if they fail, we'll just catch them in this other thing. No, it doesn't work that way. You're not supposed to do that. This is quiet part out loud time. Plaintiff's contributory infringement claim cannot evade dismissal just because plaintiffs made a tactical decision to lump it in together with vicarious infringement under a single count. Contributory infringement requires that a defendant intended its service to be used for infringement as shown either through active inducement or by providing a service tailored to infringement. Ordinarily, plaintiffs plead these distinct claims as separate counts, and courts, including those in the Central District of California, consider them separately, dismissing one but not the other when warranted. A judgment eliminating contributory infringement independently of plaintiff's vicarious infringement claim is therefore appropriate. It would resolve a discrete and legally independent basis for liability, thereby preserving judicial and party resources by narrowing the scope of remaining discovery, dispositive motion practice, and trial presentation. To conclude otherwise would permit plaintiffs to evade Rule 12 by combining multiple claims into a single cause of action. Plaintiffs themselves acknowledge that their material contribution theory is no longer viable, but refuse to formally dismiss it from the case. That refusal raises a real concern. Plaintiffs may seek to revive the theory or pursue discovery related to it. Plaintiffs contend throughout the complaints that Midjourney could or should have implemented steps to limit user outputs and have sought extensive discovery on this point, exactly what Cox has now invalidated. For avoidance of doubt and to eliminate discovery and future motion practice directed at an untenable theory, the claim should be dismissed with prejudice. Plaintiffs do not and cannot in good faith allege that Midjourney's service is tailored to infringement, i.e. that it lacks substantial non-infringing uses. Because it's not just Iron Man they're making a picture of, they're making pictures of angels and mountain landscapes, all sorts of things that infringe on nobody. As plaintiffs must concede, and as a matter of law, Midjourney service is more than capable of commercially significant non-infringing uses. As noted above, for example, plaintiffs have not alleged a single instance in which the Explore page has displayed a purportedly infringing image by default. You have to go and search for it deliberately. It is even implicit in plaintiffs' argument that Midjourney has the ability to block allegedly infringing outputs, that the service is also capable of being used for substantial non-infringing purposes as well. Otherwise, there'd be nothing left after you blocked it all. Thus, the court should also dismiss with prejudice plaintiff's contributory infringement claim to the extent plaintiffs contend that it's based on a tailoring theory. Plaintiff's apparent theory of inducement is premised on precisely the kind of ordinary incidental acts that, as a matter of law, cannot support inducement liability. Midjourney's provision of a content-neutral user gallery and search function. Midjourney's Explore gallery is algorithmically populated with other users' images, and within it is a text field that allows for semantic searching across all public images, not unlike the search bars on Instagram or TikTok. On their face, both the gallery and search function are general-purpose features that apply to Midjourney user images generally, the vast majority of which have nothing to do with plaintiffs' copyright infringement allegations. Neither is meaningfully different from the browsable categories of files or automated indexing program that matched file names with specific terms that the Ninth Circuit concluded in Fong do not send an inducing message. Plaintiffs do not even allege a single instance, not one, in which the Explore gallery, by default, displayed an image that infringes any one of their works. Every screenshot of the Midjourney website in the complaints is from a manual search that plaintiffs performed using the names of their alleged characters. They did it. That's why it's not infringement. It's not infringement when you do it with your own IP, only when someone else does. And even if they had alleged that their characters appeared in the default gallery, the possibility that a user browsing the gallery might be inspired to generate a similar image falls far short of an inducing message, one that must be affirmatively designed to stimulate others to infringe, not merely capable of doing so. For the foregoing reasons, Midjourney respectfully requests that the court enter partial judgment dismissing the contributory infringement claims with prejudice. Dismissing these claims now will conserve judicial and party resources by narrowing discovery, dispositive motion practice, and trial time directed to claims that are legally insufficient as a matter of law. Because no amendment to plaintiffs' pleadings could cure these deficiencies, the material contribution theory is foreclosed by binding Supreme Court precedent, and no plausible set of facts can support either inducement or tailoring. Leave to amend should be denied. Hugs and kisses, Cooley LLP. Yeah, again, this seems pretty solid to me, but we'll have to see what happens. The motion hearing is scheduled for October 5th. And meanwhile, the way these motions work is, I've explained this before, someone makes a motion, the other side gets to respond to the motion, and then the first side gets to reply to the response. So, Disney gets to respond by the 11th, and if they do, Midjourney gets to reply by August 25th. And then, yes, that means it'll be like a month and 11 days before the actual motion hearing. Which, by the way, is not that out of the way when you consider how packed judges' dockets are. October 5th just might be the next date on the schedule. But also, when you've got a question like this, which is a novel theory that's been affected by a very recent Supreme Court precedent, I doubt that as busy as the judge is on other cases, he won't be taking out the time to read and just try to ruminate these briefs and really try to understand them. And maybe even issue a judgment before the 5th. He might decide no hearing is necessary, but that's how it's scheduled out. The wheels of justice grind slowly, but I'll let you know if anything spectacular happens. Thank you so very much for watching. Comments for the Comment God, shares for the Share Throne. Please hit like, subscribe, and the bell. And I keep forgetting this, the hype button. If you're on mobile, go down to that little line under the video, swipe it twice to the left, I believe. There's this button called hype. Hit that. That'll get this up in the algorithms. That's a simple thing, and it helps as much as the rest. And of course, donate.bogosity.tv helps me do this as I try to squeeze this in on a Tuesday morning amidst everything else I have to do. Please show your appreciation, and that'll keep me doing more of it. Thank you so very much for watching. Until next time, stay strong and be free.